What's happening, guys? Hey, we want to have you get signed up as a subscriber right away, please. Please give me a thumbs up. I'm going to go through this kind of quickly, and this is about a allocution at sentencing, how you can nullify the sentence. This is 4 pages, so I'm going to do this kind of quick, but you can go back and you can take notes and do all that type of stuff once you hear what I'm going to do, what I'm going to say. Allocution, declaration of absolute right and refusal to accept the sentence. Do you understand? This is saying, you know, I always tell everybody they volunteer. You can cancel a sentence doing this. Allocution. You can look it up. A-L-L-O-C-U-T-I-O-N. Okay, starts off with corpus juris secundum, Federal Rules of Civil Procedure 60, Federal Rules of Civil Procedure 60B. Instructions for allocution: lack of injured party, no verified complaint, no consent of court sentence, no accepting the court sentence, not accepting sentence, refusing court sentence, sample allocution, and verbal allocution. So I know that's kind of fast. Allocution, oral declaration of rights, and non-consent at sentencing. So right before the judge is going to sentence you, he's going to say, do you have anything to say? So then you have to speak up, and I'll give you the dialogue here. The document below is read orally to the court following the conviction or whatever, and just prior to sentencing. Particular allocution below is the work of experience of one during a traffic or trial with a charge of no valid registration or plates. It can be done on many fronts. So there are two parts to allocution. A, declamation of rights and error in the trial court, along with preceding affidavits, information, declaration of non-consent, and any fines, taxes, prison. Allocution is its origins is in common law. You can look up corpus juris secundum, criminal law, 1573 through 1576. Now you got to look this up. You know, you're responsible for whatever you do and whatever you get yourself into. You know, this is just information purposes only, and I have no liability. So, you know, fix and be responsible for yourself. So one must be totally alert to ask for the opportunity to say something prior to sentencing. And now they're going to probably say, do you have anything to say before I sentence you? But if they don't, then you need to speak right up. It says, request a separate sentence hearing of at least 2 weeks. Hence, give time for you to write the allocution, to come down with what you're going to say, and you can go back over this video. Okay, number 2, do not give this information in writing to the court or opposing attorney beforehand, and as it is only valid when oral presenting to the court by the live sentient man or woman, and do not want to forewarn the enemy. The legal fiction is civilly dead and cannot speak while you're sitting down. But when you stand up and they invite you to stand up on their level, on their plane with the judge, he'll hear everything you say. And I don't think the prosecutor will or can object. And if he doesn't object, this is going to fly. Number 3, the court needs your consent to impose the sentence or the punishment or fines, restrictions of any kind. Almost 100% of the cases, the sentient man or woman becomes the surety or stand-in for the legal fiction defendant, and takes on the burden of sentencing pronouncement. It is legal fiction which is indicated, tried, and convicted. It is a sentient man or woman who takes on the sentence. The court needs the permission, consent of the sentient man to impose the sentence and gets it through the presumptions, the silence, the acquiescence, the outright consent to apply to the surety. If it is a sentient man or woman who serves the sentence, the style of the case through the conviction of the defendant is in all capital letters. The style of the sentence party is upper and lower case. Number 4, When finished with the oral allocution, one must turn around and walk out of the court, its jurisdiction immediately. Do not hear the judge or the prosecutor or anyone else, even if they're screaming, "Stop, come back here. You're going to get it for contempt," whatever it is. If one stops, you enter the jurisdiction of the court again, and you've recontracted back. You'd be a rere. I mean, that's really, it's really plain. Number 5, allocution, part 1. During the trial, you were denied exculpatory evidence, such as the courts not answering motions, notices, affidavits, or allowing your witnesses. Keep a list of omission errors due to the denial during the trial, especially constitutional guarantees. So, it's really, they're just tricky bastards. Part 2, read the following statement. Create your own written statement to reflect your specific situation and trial activities. There's no time limit on it reading. Do not give in to interruptions. They might slam a file, they might try anything, or just keep going. Keep your head. The first thing you're going to say is, "For the record, Your Honor, I'm a man living upon the land and speaking as only a man can. I was created in the image of Yeshua under the authority of the Redeemer, Jesus Christ, with all my senses intact. I am canceling the conviction and all appearances on my part, now canceling any and all contracts entered into by me knowingly or unknowingly, by methods including but not limited to verbal consent, presumptions, assumptions, deceptions, threats, duress, coercion, fraud, fiction, fantasy, illusion, or any other method, words of art, magic, just anything. They're lying, deception, misleading, just any kind of thing they're considering a practice of law. It's just wrong, and you're keeping track. A, this proceeding has failed to produce evidence of the injured party. B, this proceeding has failed to produce an affidavit verified complaint in the existence of a complaining party. There's not a real party in interest. The 17A, Federal Rules Civil Procedure 17A, my other video. This proceeding has failed to produce an injured party unto the witness stand for testimony. D, this proceeding has failed to produce a stated claim upon which relief can be granted. That's Rule 12b-6. Don't you love it? This proceeding has failed to produce any honorable ruling. Therefore, the court could only, by undisclosing presumptions of assumed intention, and this may be deemed practice of witchcraft by the satanic cabal. Look that up. Satanic cabal. It's like a legal thing. It's like a religious thing too. F, this proceeding at this court has now lost all jurisdiction by the denial of due process. Don't you love it? I have not violated Yeshua's law. I do not cause an injury to any other living man. This would be in violation of royal law of love, your neighbor as yourself, or man's interpretation, do unto others as you would have done unto you. I have not committed a crime, and there's nothing on which to convict me. Thus the conviction is null and void, and all bonds affiliated and associated with this case, whether they were with citation in form of a bid bond, appearance bond, performance bond, or any other bond written as a result of this procedure, any other, in the shape or form whatever it is, I have hereby canceled, terminate, discharged, dismissed, nullified, squashed, rescind, revoked, repealed, expunged, and I forbid the commercial use of my name or likeness of my name for profit, as all bonds created, whether on the record or not, are void ab initio, as only I, a man, can cause. I do not accept any offer to, nor consent to, nor will I go to jail, go to prison, pay any discharge fees, fines, court costs, taxes, or anything of that kind. I do not accept consent, have the right to block and impede in any way, shape, or form. I do not accept any offer nor consent to have my body in the possession, seized, or confiscated, used by by anyone or agents for their own use or the benefit of another. I do not accept any offer. I do not consent to probation, parole, post-trial release, or any other form of supervision of the matter associated with this matter and attempted to link with caution with this matter and placed twice in jeopardy of the same pretense crime. Now you have to watch out. They'll try to do home confinement and all that. I, the living man, your name, reserve the God-given rights, inalienable birthrights, waiving none ever, and all conditional upon my receipt of written statement of claim of proof of claim and contrary under your bond of office and penalty of perjury. My business is completed, perfected, discharged, accomplished, dismissed, concluded, terminated, and as Jesus Christ our Lord Savior stated, finished. Immediately turn around and walk out the courtroom. Do not acknowledge the judge or opposing attorney under any circumstance. If the judge asks for a copy of the allocution, do not respond. It is on the record and he can get it. It's there. If the bailiff stands prior in your path on the way out, ask him to arrest the judge for treason because he violated his oath of office and move on. Do not hesitate. Get out of there. So I hope you find this very interesting because I did. That means you should never get convicted of anything. Now, like I said, this is not for criminals. This is not for the shysters. This is not for self-centered or belligerent people or people that want to poke a bear in the eye with a stick or somebody that wants to go out there and mess with the system because you'll get what you deserve. They will not let you win. If you do the right thing and you haven't injured anybody and you look at the things that is in this article and the things I'm trying to say about allocution, it's very, very serious. Now there's other methods of allocution. I'm sure that if you type it into the World Wide Web and you do an investigation, which you should, and if you don't do it, it's your own damn fault. This is serious. So I get these things from people with the DUI that never hurt nobody. That's an illness, not really a crime. People that get the stop sign speeding ticket or the left of center or they get their car towed for some reason. This is not for people that want to play some game out there. You should understand who you are and what you're doing and why you're doing it. And then if you get an oops and you end up in there, this is just another method that you're responsible for. Now, this has been read word for word. And I'm sure you can find this. If you look up the allocution, there's 3 different parts. Look it up and do research and print stuff off and outline and highlight. Please subscribe to my channel. I got a donate button down there. Please tickle my donate button. I'm going to go for now, but I'm going to try to do longer videos from here on out. I have new batteries for my camera, and I know people are very sincere and they're very loyal listeners, and that makes me feel real good. And I know I'm doing the right thing. So my number and everything will be listed below this video. Please don't waste my time. Please don't get me so twisted up you go to court in a couple days. I mean, do your due diligence. It's all in this video and the other prior videos. Please watch my other videos because people call me up and the answer's right on YouTube. There's about 70 videos now. So there's no excuse for you not to be informed. It's out there for the world to see it. So we'll talk to you soon. Have a good day. Please subscribe to my channel.